Julius unaelewa lugha gani?
So Geoffrey, you will summarize for him after we are through with the judgment. I'll just read the determination. I've considered the issues raised in this petition. These issues revolve around the application and interpretation of Article 56 of the Constitution, a provision which prior to the promulgation of the present Constitution did not exist in the retired Constitution. The Constitution of Kenya 2020, it is my respectful view, a reflection of historical experience of the Kenyans, particularly during the single-party era. In order to put this petition in context, it is important, in my view, to set out the principles that guide constitutional interpretation in matters of this nature. In this petition, what is placed before this court's lap for determination is a decision of the court and the manner in which it was arrived at. It is therefore a constitutional matter revolving around a judicial determination. In the Constitution of Kenya 2010, one must necessarily start from the presumption that the provisions dealing with the judiciary were meant inter alia to correct historical deficiencies that rendered the judiciary as then constituted unable to meet the expectations of the people the Republic of Kenya had in it. As was held in the Commission of Income Tax versus Menon, it is one of the canons of statutory construction that a court may look into the historical setting of an act to ascertain the problem which the act in question has been designed to deal with. In Murungaru versus Anti-Corruption Commission, it was held that our constitution must be interpreted within the context of social and economic development, keeping in mind the basic philosophy behind the particular provisions of the constitution. Same view was expressed in the matter of Kenya National Human Rights Commission Advisory Opinion number 1 of 2012, where the Supreme Court was the opinion, and I quote, "But what is meant by a holistic interpretation of the Constitution? It must mean interpreting the Constitution in the case of Interim Independent Election Commission, application number 2 of 2011, Republic versus Karisa Chengo, as well as other decisions both locally and internationally. The article in question in this petition is Article 56, which I have reproduced. It's clear that for one to invoke that provision, two conditions must therefore be fulfilled. The first condition is that the petitioner's appeal must have been dismissed by the highest court to which the petitioner is entitled to appeal, or that the petitioner did not appeal within the time allowed for appeal. In my understanding, the petitioner can only exercise this right where legally has reached the end of the road, insofar as his appellate options are concerned, or where he is by law barred from lodging his appeal due to effluxion of time. In other words, a person who is appealing is not entitled to exercise his right under the above provision. I therefore agree with the decisions in the case of John Angala Kilimbi versus Republic and Tom Martins Kibisu versus Republic on that issue. It is, however, important to note that the article talks about the highest court to which the person is entitled to appeal, as opposed to the highest appellate court in the land. To understand this provision, one must take into account the provisions of Article 259(1) of the Constitution, which I have reproduced, and I have relied on the case of Njoya and 6 others versus the Attorney General, and the matter of the principle of gender representation. In order to live up to that spirit, the interpretation of the phrase, the highest court to which the person is entitled to appeal, must similarly be broad in order to achieve the constitutional objective of advancing the rule of law and the human rights and fundamental freedoms in the Bill of Rights, permitting the development of the law. The second respondent argues that contrary to the petitioner's contestations, there is no automatic right of appeal to the Supreme Court in criminal cases. The 2010 Constitution of Kenya clearly provides for jurisdiction of Supreme Court, which includes automatic right of appeal at Article 163 and Section 15 of the Supreme Court Act. I have reproduced both provisions, as well as the decision in Lawrence, Nditu, and 600 others versus Kenya Breweries, Hassan Joho and others versus Suleiman Said Shabal. In the above decision, the Supreme Court was clear in its mind that not all intended appeals lie to the Court of Appeal, from the Court of Appeal to the Supreme Court, and that for a matter to fall under the said provision for purposes of an appeal, the appeal must arise from cases involving the interpretation or application of the Constitution, and the appeal must originate that for the same reason that the said court could not deal with the second or subsequent appeal. In my view, I find, based on the decision of the Court of Appeal in respect of the first petitioner's appeal, that a person who is relying on ground of existence of new and compelling factual evidence must, for the purposes of Article 56 of the Constitution, be deemed to have had his appeal dismissed by the highest court to which the appeal is entitled to appeal, once his first appeal has been dismissed. In other words, the highest court to which he is entitled to appeal on matters of fact is the first appellate court, and no further unless the Court of Appeal grants him leave to adduce fresh or additional evidence. Having been denied an application to adduce fresh evidence, it's clear that he had reached a dead end insofar as he could adduce new evidence. That position was appreciated in the case of James Mwaniki Kamau versus Republic. Based on that finding, I hold that the petitioner herein has successfully surmounted the first hurdle. He has proved that his appeal has been dismissed by the highest court to which he is entitled to appeal. That brings me to the second limb of Article 56 of the Constitution. Has the petitioner satisfied the court that new and compelling evidence has become available? It is important to understand the background of this position, as was held by Mutunga CJ in the matter of Speaker of the Senate versus the Attorney General. It is essential to paint a historical canvas that helps illuminate the discourse and the resultant determination of the question at hand. History of this country is replete with situations where people, particularly human rights activists, proponents, and crusaders, were apprehended and detained incommunicado, only for them to find themselves before courts of law at very unholy hours of the day or night, having been literally dragged from their dungeons where they were kept in solitary confinement under very inhuman conditions in very pathetic bodily and mental states for the charges to be read out to them. It was said that despite the fact that those charges were invariably trumped up due to the vegetative conditions in which the said persons were presented before the court, they invariably sang guilty pleas even before the charges were read out. In my view, this must have been one of the circumstances which informed the enactment of Article 56 of the Constitution. It was a realization of the fact that in the past, innocent people were placed in circumstances under which they literally came to court singing guilty pleas as if they were chanting pre-rehearsed prayers to charges without caring whether they were true or not, notwithstanding the consequences of such pleas. To my mind, it's such cases such as this that Mutunga CJ had in the case of Jasbir Singh Rai versus Talochan Singh Rai. According to this Article 56, accordingly, the said article was meant to deal with past historical injustices and to also remedy future violations of rights and liberties of Kenyans. Article 56, in my view, provides a window of opportunity and places a future obligation upon this court to address historical or traditional injustices that may have been encountered or visited upon a particular segment of the people of Kenya under the guise of judicial pronouncements. It is my considered view that the Bill of Rights is a never again chapter wherein the Kenyans wanted to bury the yesteryear's human rights violations and immunize themselves from the possibility of such recurrences and to provide opportunity for the victims to seek redress. The chapter of Utadu attitude must therefore be forever closed and the keys to its doors thrown into abyss. Those keys must never be retrieved with a view to reopening the torture chambers of the yesteryears and filling them up with those whose only crime is to say no to a ruthless regime. What then should the High Court sitting as a constitutional do when material has been placed on its lap which clearly reveal that injustice was perpetrated to a subject in a past trial based either on clearly fabricated evidence or that certain important material was deliberately or otherwise not disclosed at the original trial and which could not have been discovered by the subject and which, had it been disclosed or not fabricated, would have led to a different finding in the original trial. Should a court of justice turn a blind eye, block its ears to such circumstances, and in effect bury itself in the hand by simply washing its hands, the conscience filed the truth and satisfied itself by handing over the subject to the prison authorities to continue serving an otherwise unlawful or unjust sentence where clearly there is new and compelling evidence disclosed. In my view, to do so would amount to the court, while undertaking its constitutional mandate of protecting the rights of subjects, abetting and being an accomplice to the transgressions of the Bill of Rights by perpetuating the violation of the rights of the subject. When the subjects come before us, wailing that they have suffered an injustice at the hands of any of the state organs, be it the executive, the legislature, or even the judiciary, the Constitution and the law gives us the power to correct the wrong. We are obligated to seize the opportunity and ensure that justice is not only done, but is also seen to have been done. It does not do justice to abdicate our mandate when we have what it takes under the Constitution and the law to restore to a person his or her liberty wrongly deprived of him or her. Justice must therefore be conducted in a manner that is not only fair and impartial, but is seen to be fair and impartial. Under Article 19(4)(b) of the Constitution, in interpreting the Bill of Rights, this court is enjoined to inter alia promote the spirit, purport, and objects of the Bill of Rights. Where credible, new and compelling evidence is placed before this court, we show that a person may have suffered injustice as a result of concocted evidence. This court would be shirking from its duty placed on it by the people of this republic via the Constitution of ensuring that justice is rendered to the people. The court would have let the people and the country down if, despite glaring injustice meted at the people, it declined to rise to the occasion and correct a patent decision arrived at from concocted and contrived evidence simply because fresh matters which were not available during the trial were never made known to the trial court. I therefore associate myself with the position adopted in the case of Nakusa versus Turorei. And speaking for myself, I would not countenance an argument which perpetuates an injustice when such injustice is driven home to me from after the parties are afforded an opportunity of being heard. I'm inclined to adopt the position in Philip Mweke Maingi versus Republic, as well as Murai versus Wainaina. In this case, PW2 and PW3 testified on oath that their evidence, which was the basis upon which the first petitioner was convicted, was extracted through coercion and threats by their mother with the assistance of the police. They were forced to testify against the first petitioner in order to obtain a conviction of the first petitioner so as to pave way for their mother to access a property. The revelation that they were so coerced only became available to the first petitioner when the matter was before the Court of Appeal, which rightly, in my view, declined to entertain the same. In other words, the issue, the subject of this petition, was not available to the first petitioner, both at the time of the hearing and the time of the first appeal to the High Court, which were the only forum at which such facts could have been considered. There was no way the first petitioner could have discovered that PW2 and PW3 hearing were coerced and threatened by their mother and the police to say what they did till the time when the door to the adduction of that evidence had been locked in his face. Facts of this case are not too dissimilar to those in the case of JNN versus Republic, where the victim of incest and key prosecution witness at the petitioner's trial recanted her testimony. Said victim explained the motive of prosecution as a land dispute and that she had been coached on what to say in court. This court considered the recanted testimony and subsequent explanation as to the motive for which it was presented as qualifying to be new and compelling evidence and proceeded to order for a retrial. I also agree with the decision in the Texas case of Villarreal versus the state. In this case, injustice is not only glaring, but appears to be smiling in defiance of justice. To paraphrase Nyamu JF, then was in miscellaneous application number 158 of 2005, where justice is denied, the gates of hell open wide to give way to frustrations, despondency, dejection, desolation, and hopelessness. People are driven to have no faith in the rule of law and resort to other means of illegal or otherwise to mete out what in their view meets the ends of justice. Justice is not a cloistered virtue, and where justice is not only done, but is also seen to have been done. The sons and daughters of the land dance and sing. The angels of heaven sing and dance, and heaven and earth embrace. In other words, nothing should be done in the name of justice which would strike a reasonable man as unjust. Spouses and couples ought to remember that their children are not their properties. While they have legal parental obligations over them, and in African setup, children have moral obligations to take care of their parents. Parents have no right to treat their children as scarred missiles or patriots against each other as means of domestic warfare. They should learn to fight their own wars and battles without involving or seeking the support of their children, particularly where the children are minors. To do so is not only unlawful, but is also immoral. Having considered the facts of this petition, I find it merited. I find that the petitioners have proved that the first petitioner's appeal has been dismissed by the highest court, which he was entitled to appeal, and that was the Court of Appeal. He has proved to my satisfaction that evidence of PW2 and PW3 in this petition were coerced, was not available at the time of the trial, and that despite the exercise of due diligence, the same could not have been availed at the trial. Therefore, he has proved that he has new evidence as contemplated under Article 56 of the Constitution. In addition, the evidence of the fabricated testimony based on coercion would have been admissible at the trial. It was evidence of high probative value and capable of belief, since it comes from the alleged victim of the offense, who at the time of her testimony was a minor under the influence of her mother. Since the conviction of the first petitioner was substantially based on the evidence of PW2 and PW3, I am satisfied that had the present facts been known to the trial court, it would probably have led to a different verdict. I am satisfied that the facts placed before this court ascertain that it is prima facie material to or capable of affecting or varying the subject charges, the criminal trial process, the conviction entered, and the sentence passed against the petitioner. In effect, the petitioners have proved that the said new evidence is also compelling evidence which has become available pursuant to Article 56. Before concluding, I take this opportunity to express my appreciation to counsel who appeared the petition for their well-researched submissions. If I have not referred to all the submissions made and decisions referred to me, it is not out of lack of appreciation for the industry. In the premises, I hereby make the following orders. 1. The proceedings, conviction, and sentence in Kithimani Principal Magistrates Sexual Offences Act case number 17 of 2011, and the subsequent decisions upholding the same are hereby quashed and or set aside. Pursuant to the provisions of Article 50 of the Constitution, which only permit for an order of retrial as opposed to an acquittal, I hereby direct that a new trial be undertaken should the Director of Public Prosecution deem it viable in the circumstances of this case. Considering the public interest issues involved, there will be no orders to quash, and those shall be the orders of this court.
Julius, kusikiza kwa fupi, koti imeangalia petition yako na imekubali petition yako, imeamuru kwamba vifungo kifungo cha koti ya chini ya Kilimani na vifungo vya koti zingine zimewekwa kando. Koti imeamuru kwamba kesi inaweza anza upya kama upande wa prosecution wataona kuna haja ya kuanzisha kesi upya.
Do you want to mention it?
Your Lordship,
Yes.
I have an application to make.
Yes.
I am kindly requesting that this court be pleased to release the order for the release of the first petitioner on favorable cash bail. Your Lordship, the first petitioner, as you correctly observed, was incarcerated subject or pursuant to a conviction that has since been set aside by this court. And we appreciate the independence and the discretion of the second respondent when it comes to the decision to charge, as well as the conduct of criminal prosecutions. In light of the fact that we do not know what direction the second respondent will take, it would be unconscionable to have the first petitioner remain in custody as he awaits for a trial that he doesn't know when it's likely to take place. Lordship, under Article 9(1)H,
Yes.
of the Constitution, it makes bail a constitutional guarantee in circumstances where there are no compelling reasons for its denial. In applications of this nature, the key and the main consideration that the court looks at is whether or not the applicant, once released, will attend court for the trial. The first petitioner hearing attended court all through, religiously and as and when it was required during his trial. He never missed even a single session, and the court record would attest to this. Lordship, I rely on two decisions the first one being Zahira, Habibullah, and another was a state of Gujarat and others, and JNN versus Republic. The Lordship, both decisions are part of the court record as they have been relied upon by the parties in their submissions.
Yes.
In the Zahira Habibullah case, the Supreme Court of India, after directing or after granting an order for a trial, directed that the bail terms that were obtaining at the time of the petitioner's trial be reverted to. In JNN, this Honorable Court granted a petitioner whose petition for a trial had been granted a cash bail of Kenya shillings 30,000. We are requesting that you be pleased to order for the release of the first petitioner on favorable cash bail terms. If I will just draw from your wisdom in the judgment, if there is injustice that is so glaring and smiling in the face of justice, this court cannot follow its hands. We request this court as a court of justice to intervene and secure the liberty of the first petitioner hearing, which has been unlawfully or unjustly taken away from him. He's been waiting for close to 10 years, and I hope today will mark a new beginning for him as a free person. That is all in the logic.
My Lord, on my part, I'll be praying 7 days so that we can respond to the application. Secondly, my Lordship, I think the fee will be contemplating on appealing on the decision of the court. For me to get proper instruction, I will be praying for 7 days.
So, Maweo, did you have the proceedings of the lower court here?
Yes, Your Lordship.
They are in which bundle?
They are annexed to the petition itself in the affidavit of the first petitioner. And also
Yeah, I've seen them.
is JWM to Your Lordship.
So I've considered submissions of counsel based on the decision of this court. It is now clear that the first petitioner is now deemed to be an innocent person unless the outcome of the trial proves otherwise. I do not see any compelling reasons to deny him his constitutional rights to bail based on the decision that the DPP may take. Since he was out on bail pending his trial, I hereby reinstate the same orders. He may be released pending trial. Accordingly, he is admitted to the similar bail on similar terms. He was released on, I think, 200,000, sure, with the one surety of a similar amount, and he can still be released on the same conditions.
Your Lordship, with your very kind permission,
Yes.
will you kindly consider an option of a cash bail?
Cash bail.
Yes, Your Lordship. The circumstances have changed. The first petitioner has not been in contact with anyone for quite some time. So it may be a challenge getting someone to stand in as surety for him. We would be most grateful if you could kindly consider the option of a cash bail.
Yes, so he can be released on cash bail of 30,000. When do you want to appear before the court in Kitimani for further orders?
Even Monday next week will be
Monday is which date?
21st.
Okay, so you appear before that court on Monday the 21st. I have not made any orders with respect to the magistrate because I think the magistrate is no longer there on the proceeding.
Your Lordship, my learned senior has
Yes, Mr. Kama.
Please, Your Lordship, on behalf of the petitioners, we'd like to appreciate the courts for hearing this matter painstakingly and extremely patiently for over nearly a year now. Your Lordship, clearly the decision that the Honorable Court has made today depicts the first petition a seemingly interminable decade of crisis and pave the way for justice to be done at last and a great family reconciliation. We are most grateful, and we also like to observe and verbalize our gratitude for the fact that this case, in the days of this deep darkness, has really tenaciously kept the doors of justice open, and we salute the court and wish it a very great festive season as the court takes a very deserved rest. Thank you very much.
Thank you very much. I hope I'm going to have any rest.
thank you, Your Lordship.
There are a few typos here that will be corrected, and then you'll be able to get copies of it. Yeah.
Tuliza, kuna shoot ya nani? Kuna shoot Panama. Oh, Pokoti. Ni material nyingi kwa bila. Unaweza ipata publicly. Iko inakuwa inako public. Unaweza ipata wapi? Unaweza pata kwa Facebook. Facebook. Kwa YouTube. Kwa YouTube. Ni ya court. Ni ya nani? Ni hawa nini? Hawa akikote utakuja kuuliza kwanza.
Nimesema ni kule.
Toka duma zumeti kana to rekodio to rekod
Whenever you are ready, let me know, please.
Nana naongea mawe.
Mahali group
Tunaenda live, so we brief, and then Dorcas ongea pia.
Okay.
14. Like 1 minute, 2 minutes. Kiswahili tafadhali. People stand by.
We start with the lawyers and then
Tuko ready? Tuko sawa.
So Victor, we are ready. Whenever you are ready, Victor.
Okay. Tumeshukuru leo kwamba hii kesi ambayo tumekuwa tukifuatilia imeamuliwa, na ni kesi ambapo nafikiri wananchi waliona sana ilipozinduliwa na Citizen kwamba Bwana Wambua ametumikia kifungo miaka 10 kwa sababu ya ushahidi wa watoto wake ambao walisema kwamba walishurutishwa kutoa ushahidi kwamba alimnajisi mmoja wao, lakini alipokomaa na wakajua walivyofanya si haki, waliitisha mazungumzo na wanahabari na wakawaambia ukweli, na kama tume ya kutetea haki za binadamu tuliweza kuichukua hii kesi, na leo Justice Odunga amesema kulingana na article 56 ya katiba ya Kenya, hii kesi inaweza kuanza upya. Kwa hivyo Bwana Wambua afunguliwe na kesi ianze upya kule Kidimani. Kwa hivyo tunashukuru kwamba hiyo miaka 10 imeisha na haki leo, na tunatumaini kwamba sasa familia itaweza kurejeana na kurudiana na kuelewana, na tunawatakia mema. Asante. Nataka kumshukuru Bwana Cyrus Maweo ambaye pia ndiye aliyetuongoza katika hii kesi, hasa kwa kuwasiliana na parties, na pia tulifanya kazi yote na yeye, na nataka pia kushukuru wenzangu wote wa commission kwa sababu ya kujitolea kwenu kuhakikisha kwamba haki imetendeka, na tunashukuru.
Siku ya leo namshukuru Mungu tu kwa yenye ametenda. Ni miaka mingi, miaka 10 bila wazazi. Lakini siku ya leo ameona ni vyema nikuwe na mzazi wa baba ambaye alifungwa bure. So nashukuru sana. Na naomba tu pia si eti kwa babangu tu, bali pia kwa wenye walifungwa, hivyo tu babangu alifungwa. Pia Mungu tu atende jambo kwa ajili yao, wakaweze kufunguliwa mahali pale. Ni kwa kuwa tunajua the truth will set us free. Katika kitabu cha Yohana mstari wa 8:32 inasema, tukisha ufahamu ukweli, ukweli utatuweka huru. So nashukuru sana na Mungu awabariki.
Miaka 10 imekuwaje kwako?
Hiyo miaka 10 imekuwa mingumu sana. Nimekuwa tu na hukumu mob kwa roho yangu. Sijakuwa na amani hata kidogo. Lakini just for today, nashukuru amani yangu nimeipata.
Nini ilikusukuma kupasua barika ama kupeana ujumbe kuhusu kesi? Nini ilikusukuma?
Chenye kilifanya ni useme huu kweli na nisimame, ni useme ni kuwa hakuna vile unaweza kaa na ukweli ndani yako na ukae na amani, mwingine anaumia. So I